first of all, I want to thank everyone who was there in Scranton in person or in spirit. It was really a big help to the legal team, to Mumia, to the struggle. In sometimes, yes, in telling the powers that be that there are people there, but also in very intangible ways, because when I'm running around in the well of the courtroom doing something, and then I have occasion to turn around and see friendly faces and supportive faces, that really makes a difference to what I'm doing as well, because I'm operating in the enemy arena, and to see people who, and to feel the support from the rear is really very important. And so I want to thank you for that. And we have we had a great 3 days there, but it's important to remember at the outset that I think the 3 days were a big victory, but Mumia yet doesn't have the medication that he needs to fight this disease, this hepatitis C. And so while we had, I think, a very successful hearing, we don't have the victory, the legal victory that we need to make sure that he gets the medication that he needs, and so many other people need. The issue in this case is what the hearing was a part of was a motion for a preliminary injunction, which is that we're asking the court to issue an order requiring the DOC to give him the latest antiviral drug. And it's called a preliminary injunction because while the case has been filed, there's been no discovery, it's not the trial on the merits, and basically we're asking for immediate relief. And so it was our burden to prove that the DOC is violating his 8th Amendment rights by refusing to give him these antiviral drugs. And it requires proof far more than just simple negligence or malpractice for a federal court to issue this kind of order. It requires the kind of intentional mistreatment that is almost, as the Supreme Court would say, for the very purpose of causing pain. That's the standard that we have to meet. So when we're also thinking about what this judge is doing, we have to remember that he is going to be applying this particularly onerous standard when he ultimately rules in this case. So there was issues of fact that the judge had to resolve at the evidentiary hearing. We had initially written papers, the DOC responded, and we asked to go to court for oral argument. And the first interesting thing that happened was after the judge got this letter saying we'd like to come to court for oral argument, we get a call from the judge who wants a conference. And the judge says, well, you certainly can have an oral argument, but after reading these papers, I need to have a hearing. I need to know what the deal is here on the medical issues, on what DOC has done or not done. And, I think we had the telephone conversation on December 2nd, and the oral argument was for December 18th. And he said, are you going to be prepared to go December 18th? And it was like, I would ordinarily want like 2 months to prepare for such a hearing. But we had to say, of course, yes, we have to be ready to go. Our client's life is at stake. And the DOC would have to be ready to go by that date as well. So, this judge, he's a Democrat, an Obama appointee, for whatever that means. He's never been a prosecutor. He practiced labor law in the Middle District of Pennsylvania. Is he a radical? By no means, no. He, I think, obviously was engaged by the issue, and at a minimum was engaged and wanted to hear what we had to say. So at the hearing, the issue was whether he would be entitled under the 8th Amendment for this medication, and we had to prove the violation of the 8th Amendment. So we had to prove, first of all, that he was sick and that they intentionally disregarded his sickness. So Mumia was the person to testify first and testified for hours about what he went through for the last 18 months. And I'm not going to go into that in detail because a lot of that is online and the descriptions of him, but he was fabulous. Mumia, as people know, wasn't present in court, but there was a live feed to the prison in Mahanoy where he was on camera and the entire court was on camera. So he could see what was going on in court to a limited degree, and we could see him. And that was, of course, I would rather have had him at the table with us, but whenever they move him, it's torture. They wrap him up, as he says, like Hannibal Lecter, and it's a horrible experience. So it was, he chose to proceed that way. Initially, and this is an aside about the judge, which I kind of liked, the DOC said, well, he should only be on closed circuit TV. I'm imitating Laura Neal, the lawyer for them. He should only be on closed circuit TV during his testimony because the resources of the jail, we have to have someone in the room there, and it's just too much. The judge says, you'll have someone in there, and you'll have a phone so his lawyers can talk to him whenever they want. And so he wasn't buying that kind of stuff, which was a good sign. So he described what he went through. We then were able to call our expert, Dr. Joseph Harris, who has been spoken about in other proceedings and who was a person who gave the first significant diagnosis, who essentially linked the skin condition, the horrible skin condition of the past 18 months, to his hepatitis C, and made that link, made the link to his anemia, and made the link to other problems that he's having. Joseph was great. I think the judge, from sitting there, and I think people who were there really liked him, because he didn't come across arrogantly, he came across credibly, he knew his stuff, but he didn't exaggerate. His testimony came across really well. And I have to add, before talking about getting away from Mumia's testimony, I thought the judge kind of really kept looking at Mumia on the camera too as he was talking. And I think Mumia never complains, right? So he did well, I think, for him in describing the suffering he went through, but to the extent that Mumia is always understated about himself, he came across very well to the judge. When he didn't remember something, he said, I don't remember. No, not really. He was very, very, very understated and credible. And then, of course, we had the two dynamo witnesses, I called them, in Dr. Suzanne Ross and Dr. Johanna Fernandez, who who were important not only because they described their consistent interactions with Mumia over the last 2 years and the deterioration in his health, both physically and mentally, but also placed, I think, what was going on in the political context of the effort to free Mumia, because they were two, obviously, of the most active and long-standing supporters of Mumia, so it was incredibly important to be able to present their testimony at the hearing. And I think it created, and the judge let us go with it. I thought we would be cut off, several times, and they didn't object, so okay, I'm not going to stop them either and let them talk. And that was really interesting. So then we came to the state's case, which I think our case went in really well, but boy, I had no idea the state's case was going to be would be even better than our own case in a lot of ways. It was really, they called, and I'm going to just do a few anecdotes to give you the sense of it, because it'll take too long. There were so many stories, and when we get the transcript of the proceeding, it'll be up online, hopefully, and you'll be able to read it, but I don't think it will capture the drama of what happened in court. But let me just give you some of the undisputed facts as come out in the state's case, and that we, in our case, which they don't dispute. Number one, that Mumia indeed does have chronic hepatitis C and has probably had it for at least 30 at least 30 years, which put him in the higher risk of progression to serious liver disease. Their own expert, and somebody help me with his name again, that pig from Horizon. Cowan, whose father was in the Nixon administration. So you know he comes from a great genius, and convicted of fraud and bribery, which we tried to get in, but the judge wouldn't let us. Yeah, he was. Well, what happened was, and it's a long story, him and his father were indicted. His father took a plea to guilty on the condition that the charges against his son, our Dr. Cowan, would be dismissed. This was about 20 years ago, and he's since gone on to run the prison system at Rikers Island. Isn't that wonderful? The health care at Rikers Island, which they just lost the contract December 31st. But this was the guy who was taking care of our loved ones at Rikers Island. So he testified, and I didn't really expect this, that under the best of circumstances, Mumia has stage 2 fibrosis, which means he has liver damage. That's based not on a biopsy, but the blood work. So they admit he has stage 2 fibrosis. Under his own calculations, the state's own calculations, there is a 63% chance that Mumia has cirrhosis right now. Not that he has a 63% chance of getting cirrhosis at some point in the future, that he has a 63% chance of having cirrhosis right now. So he continues to have a low platelet count, which is a sign of liver damage and advancing hepatitis C. The skin condition, though people have probably read, has significantly improved, and we're really happy about that, and he's gained weight and he's more comfortable. It hasn't gone away. I spoke to him just the other day, and it's still present, and he has the itches still. But so this is after, think about it, 18 months of treatment. It still exists. Now, the state, this is everything that they agreed to. There's things, of course, that we don't agree to, that's in Dr. Joseph Harris's testimony and so forth. But this is what they agreed to. But on the basis of this, it's still their position that he's not sick enough to get this drug. And that all they need to do to satisfy the Eighth Amendment is take his blood every so often, make sure it's not getting any worse, test his sugar, test his this, and don't worry about it. If he reaches a certain point, when he is sicker, we'll think about getting him the drug. So on the second to last day of the hearing, they stupidly called this guy Steinhardt to the stand, who's the head of medical at Mahanoy. He's not a doctor. And we asked him, well, is there a protocol for hepatitis C treatment? And he said, oh yeah, there is. And of course, they've never produced it in the course of the litigation. And we made a fuss in front of the judge, and we said, Judge, this goes to the heart of our case. They have a protocol for treatment, get them to produce it. The state gets up, we'll produce it, but it's confidential, and because we don't want a lot of people, it's temporary, and we're continuing to work on it. So finally they turn it over, and they wanted us to keep it confidential, which we refused, and eventually they just let it go out. But essentially, in this protocol of the Department of Correction of Pennsylvania, without getting too medically technical, you have to have cirrhosis before they will before they will consider giving you the new antiviral treatment. If you got the cirrhosis and you're in danger of what's called portal hypertension, you'll go to this committee, and the committee will vote as to whether you get the antiviral treatment. And what portal hypertension is, and both Mumia and Dr. Harris now call me Dr. Boyle because they think I learned so much of this stuff, is the liver is so calcified from the hepatitis that the blood going in can't get into the liver, so the blood vessels leading into the liver, because they're all backed up, start bursting. And that can cause internal hemorrhaging and death. That's why hepatitis C, untreated hepatitis C, is so dangerous. Any kind of hepatitis, but you know, what we're dealing with is hepatitis C. And essentially that's their protocol. And they say, well, we're only, you know, we want to treat the sickest first. We got no problem with that. Treat the sickest first, but treat everybody, right? Treat the sickest first, but treat everybody. But they have no plan to treat anybody unless they have this horrible advanced stage of hepatitis. And from what I understand, and I think Pam knows more about the outside of the prison stuff, that's essentially the policy within the state of Pennsylvania. It's for the transit workers, for people on Medicaid, for everyone. They're not giving it to you. They're not giving it unless you're really that sick. So I want to just, tell one of the anecdotes about this false information. So we had put in these papers for the preliminary injunction with Joe Harris's declaration, a lot of articles, references to some other experts who supported his opinions, and they filed a declaration of this Dr. Paul Noel, who sat in court for the 3 days, who was until recently, who now, is the head of medical care for the whole Pennsylvania DOC. And he was kind of a weird guy, because I watched him sit over at the other table, and he was kind of like twitchy and a little, anyway, he was a kind of a strange guy. So they called him as a witness, and what he had said one of the things he had said in his affidavit was that one of the reasons we're not going to treat Mumia Abu-Jamal is that he has a very low viral load, and it could be many, many years until the viral load goes up, and he would need treatment. Now, we checked this with not only Joseph Harris, but other hepatitis C experts, and basically it's not disputed that the size of the viral load, that is how much virus is in your blood, has no relation to disease progression or how sick you are. This is different than, for example, HIV. If you have a high viral load in HIV, you're very sick. Whereas with hepatitis C, you can have a low viral load and be very sick, and a higher viral load and the disease hasn't progressed so much. So we were prepared to cross-examine him, amongst other things, on this point. So one of the first things I did was I got out his affidavit, and I walked up to, may I approach the witness, Your Honor? Yes, you may approach the witness. And I handed him his affidavit, and I was going to ask him, did you write this, and isn't that not true? And so I handed him the affidavit, and I said, is that your affidavit? And he says, this is not what I signed. So immediately I'm thinking, my first thing is, well, I messed up doing something, right? Or did I take the wrong paper off because if people were in court, they saw it was like an igloo of paper on the desk, right? And I run over to Brett. I say, Brett, get me that declaration. Is this the right declaration? Because I'm thinking I'm handing him the wrong sheet of paper, right? So no, I said, this is the right sheet of paper. And I show it to him again. And I said, well, is that your signature on the last page? He says, yes, that's my signature, but this is not the declaration that I signed. I said, well, what do you mean? Well, if you had a half hour, I would explain it. So the judge is getting seething, and he, at this point, he's really so there's kind of a break in the proceedings, and I said, he said, well, something's wrong in this declaration, and he said, he pointed to the paragraph where it said, Mumia has a low viral load, so therefore it'll be many years before he'll require treatment. He said, when this was initially showed to me, I said that wasn't true. And I refused to sign that affidavit. And I said, well, when was the first time you told Laura Neal, who was their attorney, that this was false. Oh, well, he said a few different answers to this. Oh, well, right away. And so the judge was like, well, and we were like, well, but this was filed with the court back then. So did the DOC counsel intentionally file something that they knew was false? And she gets up and says, oh, no, Judge, this was a clerical error, and, it shouldn't have been done. It was just a mistake. But then, I hand it to my co-counsel, Brett. He went to their memo of law, which quoted from the declaration, right? A memo of law is a separate document, and it quoted from that paragraph of the declaration. So if it's quoted in a different document, it's not just a clerical error. And so we pointed this out to the judge, and the judge just said, yes, I know, I'm reading the memo now. He had it on his computer up there. And so we asked a few more questions, and we knew that part was going well when the judge said something to me like, Mr. Boyle, do you have any questions about this? Because if you don't, I do. So I said, Judge, go right, I'll turn the witness over to you. I don't want to snatch defeat from the jaws of victory. I will shut up, I will sit down, I will let the judge ask the questions. So the judge, asked a few questions, and Laura Neal gets up again, and, we don't know how this happened, Judge, and we kind of moved on from there. But then there was another point where he says that in his affidavit that the infectious disease specialist that they consulted with concluded that Mumia's skin condition was not caused by hepatitis C. He also swore to this. And we had just gotten the report of the infectious disease specialist where he said the opposite. He didn't conclude it was related to hepatitis C, but he said, given that we've run hundreds of tests on this man and he still has the skin condition, it is probable or likely or at least should be considered that the skin condition comes from the hepatitis C. And we had this in writing. So I showed this to Noel. And I said, well, this was the same infectious disease person, right? I think it was Gadea. Yes, that's the only one you ever spoke to. That's right, the only one I ever spoke to. And he never said it's unrelated, did he? Well, let me look at my notes. And I just handed him his notes and sat down and waited for him to look through the notes to find whatever entry was there saying that it was. And of course, he couldn't find one. So, that was just, I think, the level at which they have sunk to in this case. But, there's one observation I have to make about it, which I think applies to Mumia and other prisoners. 99% of the civil suits filed by prisoners around conditions are done pro se. That is, by themselves. And they don't get hearings in court where the kind of stuff can be exposed. Mumia, in part because all of you and because of the legal work, he got a hearing in court where these lies could be exposed. So it makes you wonder how many men and women are in the jail who have viable claims and they lie about them and it's never exposed, and who may have died as a result of mistreatment and all of that. So where do we go from here? And then I'm going to shut up. The hearing ended after the 3 days. I don't think it could have, always looking back on it, we should have done this, we should have done that, but I think all in all it went very well. We're expecting the transcript of the hearing any day now. Once we get that transcript, we have 21 days to file post-hearing briefs. We're going to file simultaneous briefs, which means we're going to file them on the same day as the DOC, and then the judge is going to reach his decision. He said in court anyway that this is the #1 case on his docket, and that he will issue a decision as quickly as possible. If he is going to, either way he rules, I don't think it's going to be really quick, but I don't think it's going to be long either, because he's going to be, this judge seems to be very thorough, and if he rules in our favor, he's going to want to back it up by a lot of facts and a lot of law. So don't be surprised if it takes him a while, but with him a while I think will be a month, which for some judges is a short time. So that's where we're at. And, you know, but he has a tough standard to apply, you know, a standard that's not favorable to people in jail, a tough legal standard. And so it's critically important that, I think that there's a big momentum right now in terms of getting hepatitis C treatment. The suit by the transit workers, the federal government telling the states they need to give it under Medicaid if they're not giving it under Medicaid, and a lot of clamor about it. And I think the working with the other families of other prisoners in Pennsylvania, in New York, in other places, California, is critically important, because I think that the movement to get treatment for everybody is as important, and I think even more important than what we're going to be doing in court in the next couple of months. So, you know, I guess the lesson of that is to keep the pressure on, and to keep fighting for hepatitis C treatment for all. It's really obscene that this cost $1,000 a pill for 84 days. That is obscene. $84,000 per person. So if you say the low estimate in Pennsylvania is 7,000 people with chronic hepatitis C, that's the low estimate. I think there may be an estimate. So multiply 7,000 times 84,000, and that has to come out of their state budget. It's obscene. But if all the states got together, you know, the big states like Pennsylvania, New York, Texas, California, Florida, Ohio, and they went to the drug companies and said, look, we'll buy your drug, but we ain't paying no $1,000 a pop. It's $10 in Egypt, right? Or something like that? $4 in India. But, you know, we have wonderful patent laws in this country, so that you can only sell it, you know, if they have a patent, they're allowed to sell the price. And they have a patent here. So it's obscene what they're doing. That's about it. Thank you once again, and free Mumia.